Matthew. I've got more stories about my family, but not in front of the Portland Business Journal. I'm very excited to talk about this very interesting and very challenging issue. I'm even more excited about the panel that we have today because they're great. This afternoon, to my immediate left, is Dave Kopilak. Dave is a business attorney. He's a shareholder with the Emerge Law Group, and he has represented and advised clients at all stages of cannabis growth in connection with a wide variety of business transactions and legal issues. Dave is also the drafter of Measure 91, if you didn't know that, so we've got a rock star in our midst. But guess what? We also have Marjorie Elken, and she's a rock star too. She's an attorney, a business attorney with Zupancic Rathbone Law Group. She focuses on advising businesses on litigation matters and all types of transactional matters. As part of that practice, she advises clients about how to do business with enterprises that are trying to navigate the rapidly evolving laws and regulations for legalized marijuana. So she's going to talk mainly about leasing issues, I think from a landlord's perspective mostly. So the plan today is I'm going to say a few things. I'm going to talk for a couple of minutes about the background, try to set the stage for how in the world we're even talking about this stuff right now. And then our panelists are going to talk, and then we're going to have some time for questions at the end. So one point to make, is, as we've kind of mentioned already, is that this is a very, very dynamic, evolving, changing area. Let me give you a very concrete example. So if you saw our flyer, we had 3 speakers lined up today, but we have 2 here. The third was supposed to be from M-Bank. And I dealt with the folks at M-Bank for about a month, and they were very professional, very courteous. They're great people. I really enjoyed talking to them, and I was very excited about having somebody here to talk about banking issues because they're very complicated. So about a week ago, I got an email from my contact at M-Bank saying, sorry, Tom, we can't appear on Wednesday. And that was it. So I don't know what exactly happened. I don't have a reason for why they're not here. I want to stress that they're great people, and I'm sure they're going to be back soon, but I don't have a good explanation for why they're not here, and I'm sorry. But that just shows how things are changing all the time around us. So I'm going to talk about banking issues a little bit because I think they're so interesting. I'm going to try to work it in here. I'm not a banker. I'm not a banking lawyer, so the bar would call this malpractice, but I'm going to say a few things because I think it's interesting. I think it needs to get out there too. So, as you may have heard, and as a lot of you probably know, the very first thing you need to tell your clients or your customers or anybody, and the most important thing you need to know, is that marijuana is and remains a Schedule I controlled substance under the Federal Controlled Substance Act of 1970. According to the government, the federal government, it's a dangerous drug, and in general, it's a crime under federal law to manufacture, distribute, or dispense marijuana in any circumstances, unless you're doing a federal education program. So it's a source of revenue for large-scale criminal enterprises, gangs, and cartels. So as a Schedule I controlled substance, marijuana is on par with LSD and heroin. Meth is a Schedule II substance, if you didn't know. This means that if you're a real estate broker or a banker, a landlord, a lender, a butcher, a baker, a candlestick maker, you can be prosecuted under federal law for doing business with a marijuana business. You can be prosecuted for aiding or abetting. You can be prosecuted for money laundering if you take their money for payment for your services. Now, I don't mean to scare the bejesus out of everybody, but I kind of do. But if you bear with us today, I think we'll arrive at a point where maybe you might have some comfort. The other point that I think was interesting was that as a Schedule I substance, marijuana, according to the federal government, has no accepted medical use in treatment. So let's fast forward to 1998, and Oregon passes its Medical Marijuana Act. And this act provides legal protections for qualified patients. It protects patients from criminal prosecution under state law, not federal law, but state law, for production, possession, or delivery of controlled substances. Presently, there are 23 states that have medical marijuana laws, plus the District of Columbia. So I'm not sure if that means 4 out of 5 doctors approve of it, but about half the country has these laws. So where we might find some comfort is the Cole memo. So as some of you may know, and others may not, in 2013, James M. Cole, who is the Deputy Attorney General, sent out a memo. And he said, essentially, okay, fine. The federal government has limited resources, and we're going to recognize a distinction between seriously ill users of marijuana and large-scale for-profit commercial enterprises. And we're going to deprioritize prosecution of legal use if the state enforcement of its laws is robust, whatever robust means. And so the memo lays out some priorities that the government is going to follow, things that it is going to focus on, and Dave and Margie are going to talk about this some more, so I'm not going to belabor the point. But pretty much the federal government is going to look at operations that sell to minors, if they do, operations across state lines, and the prevention of gangs and cartels. And then, in 2014, the Financial Crimes Enforcement Network came out with a memo of its own, and FinCEN is with the Department of Treasury. And this memo provides guidance for financial institutions to comply with the Bank Secrecy Act. And I would submit to you that it really imposes some duties. Margie's going to get into some of the due diligence that banks are required to follow to bank with marijuana businesses. The point I was going to make is that under FinCEN, if you're a bank and you want to bank a marijuana business, you have to file a SAR. And I think people in banking know, and I'm not familiar with these that much, but banks are required to file, on occasions, suspicious activity reports, or SARs. For a marijuana business, a bank is required to file a SAR for every single business with which it does business, even if that business is in full compliance with state law and otherwise not doing anything wrong. So you have a bank, if they do business with a marijuana business, they will file a marijuana limited SAR. That's the basic version. And that SAR includes the name of the account holder and their address. So already, if you're a grower or you're in the business, the government's going to know who you are. They're going to have that information. If a bank finds that the business may be engaging in actual suspicious activity that may violate some of the, or implicate some of the priorities of the Cole memo, then the bank is required to file a marijuana priority SAR. And that is, they must provide details again of the account holder, the address, and the nature of the activity, and why they think this might implicate the Cole memo priorities. And the bank also has to include details of its transactions with this party. And if the bank is convinced that this account holder is violating federal law, they have to file a marijuana termination SAR and terminate that party as an account holder. So what the FinCEN memo does is it essentially foists some drug enforcement duties upon a bank. And then the bank has to disclose that to the federal government. And so what we're seeing now is that if you want to be, what we're seeing is some of the most opaque businesses, the most underground businesses in the country now must become the most transparent businesses in the country. Not only that, but the banks, in reporting their transaction activity, are arguably reporting their criminal conduct. And they could be implicating themselves. So I think this is why, as far as I know, MBank is the only bank in Oregon doing this, because I think a lot of banks are saying, no thanks, I'm good. So that's about all I wanted to cover. I'm assuming a lot of people are familiar with the medical marijuana laws. I'm going to touch upon a few things here. This is about 30,000 foot level. May not be informative to everybody, but in general, under Oregon's program today, a medical marijuana is grown by either the patient or a designated grower. A grower can grow for up to 4 cardholders. Each cardholder can have up to 6 mature plants. Growers now can transfer usable marijuana either to a cardholder or, with the cardholder's permission, they can transfer usable marijuana to a dispensary. And then, although a grower cannot sell marijuana because that's illegal, you can get reimbursed. And what does that mean? I think that that's evolving. put it that way. And any cardholder can possess up to 24 ounces of marijuana. As of January 1st, there were 69,865 registered patients. So the only reason I mention those things is that I want to get some background on medical marijuana. We've got the drafter of Measure 91 here, and so I'm going to turn it over to Dave, and he's going to talk about Measure 91 and what's going on now.
Hello, everyone. Thanks, Tom. Cut me off when I'm exceeding my time. I told Tom I'd tell a quick story about how I got involved in this. I worked for 19 years at a large law firm. I'm a mergers and acquisitions business attorney, so I was not an activist of any sort. I was just sitting in my office cranking out documents for practically 2 decades when, out of the blue, literally, came a client who asked me to form a nonprofit, which I had done before, and expressed interest in drafting a ballot measure. This was back in 2012. In 2012, you might recall that we had a ballot measure that failed, and that's when Washington and Colorado's had passed. So we started down the road in 2012, but there was a competing measure, so my guys kind of backed off. But when that failed, we got right back to work in November. So in the beginning, our firm had this intake policy, right? We weren't allowed to take clients unless we went through this slightly bureaucratic application process. It was a credit check, it was a background check, it was that kind of thing. I described the client as a person who wanted to start a nonprofit and perhaps write a ballot measure for marijuana. Within an hour of sending that through our little system, 2 white-haired guys walked in my office and said, what is this? Is this a typo? Literally, like, what are you doing? And so it was the beginning stages of how our firm tried to figure out what they were going to do with marijuana. This went all the way up to our board of directors, and there's no real legal issues with forming a nonprofit or writing a ballot measure or advocacy. There's nothing, illegal federally about that. But nevertheless, the firm was very concerned from a reputational standpoint about how that would look. And there was folks within the firm who didn't want to do this at all. I suppose my side prevailed, and the firm decided we could do this. And if a particular client had a problem with it, that was just the way. We'll see how the chips fall. And then, as we started to draft the ballot measure, it was very interesting to see how the firm was reacting to this. At first, it was kind of hesitancy. Then it was, we're on the cutting edge. I mean, literally within a month or 2 when this started to happen, and there was some press about it, the firm management got very excited and thought, like, this is something that we can really parlay, and we're setting the groundwork here. And I was sort of touted within the firm as being on the cutting edge of the law, which was an interesting place for me to be. But then what happened, based on Sam's legislation back in 2013, House Bill 3460 came. This is what licensed dispensaries. Before that, this was completely in the gray market. There was businesses going on for sure, but there was no legal businesses. Nobody had to file an application. People didn't form, entities. There was not much payroll going on. There was not much anything going on above board. The legislation required people to. So 2013 was the year where the business started to happen. So that was when I then started to know a fair amount of people in the industry who started to come to me for entity organization, projects. So then I went to the firm and said, okay, hey, this is a great marketing opportunity here. I've got a lot of people asking me to form entities for them. And they basically said, no. So they were on the cutting edge, but they were not really on the cutting edge, because that was where they started to think about aiding and abetting, about on a federal level. They started thinking about Oregon State Bar ethical obligations and things of that sort. So soon after that, I left the firm and started a small firm, and that's where we are today. It wasn't entirely for that reason, but that's what happened. So now I partnered up with a criminal law attorney, which is a strange partnership, one would think normally, but I think absolutely sort of crucial in this industry. So we've got a couple of business attorneys, we've got a tax attorney who who deals with these very peculiar tax laws that apply to cannabis industries. And we've got a criminal person who's sort of a compliance regulatory person. And we just sort of went all in on this industry. The Oregon State Bar was silent on the issue. Several bars from around the country had kind of done this or that. Washington was taking its sweet time as to whether Washington attorneys could advise Washington cannabis-based clients. We kind of just went for it on the theory that common sense would eventually prevail, and it seemed hard for me to imagine having an ethical complaint against me by advising clients in accordance with state law. So I just sort of, we took that approach. And lo and behold, it hasn't happened yet, even now 2 years later, but the House of Delegates of the Oregon State Bar has passed a resolution. It's got to be approved by the Oregon Supreme Court, but they're basically giving the green light to attorneys finally to, it's not unethical to represent cannabis clients. That's actually the easy decision. I don't know if you're all professional, what your ethical governing board has decided or not decided. I mean, it's very common to just not avoid the issue. So I don't know where you guys are at on that, but we just sort of plowed ahead without regard to it, just again thinking we were going to be okay. The more difficult issue is whether you're aiding and abetting from a federal standpoint, right? So it's one thing for the Oregon State Bar to tell me that I can't practice law or I'm doing something unethical. It's another thing to have the federal government knock on your door and say you're aiding and abetting somebody. So after long consultations with my criminal law associate, I mean, we've gotten, and Tom mentioned the Cole memo. This is kind of everything right now. None of us would be here, and there would be no businesses going if the federal government did not take a position that is stated in a Cole memo. This was in reaction. It came about 6 months after, or I guess 8 or 9 months after Washington and Colorado had passed their ballot measures. This is a policy. This is a federal enforcement policy. The law has not changed. So everyone's going forward based on this policy, which the federal government has adhered to. They will not come into Oregon or Washington or Colorado and basically make claims against a state compliant business. That is a policy that can be revoked. I mean, right at the bottom of the policy, nobody can rely on this. It can be revoked overnight. It can be ignored. I mean, this is a directive to federal prosecutors to advise them how to allocate their resources. Some federal prosecutor could just say, well, I feel like using my resources a particular way and I'm going to go for it. That's not happened in Oregon. My colleague knows the federal prosecutor here, and everyone's adhered to it. So now, Eric Holder, the Attorney General, is being replaced now. His replacement is up in front of the Senate, giving her position on things. And she was asked point blank the other day about marijuana, and she says she disagrees with Obama's policy. I don't know if that's just sort of I just want to get confirmed language or what. But this is the sort of this could all come crashing down if the feds come up with a different policy. And then, of course, looming in the background is the 2016 presidential campaign and race. And so, you can look at the list of characters who are going to be likely candidates, and some of them, we think are fine, but there's others who, if somebody who's not on board with this policy becomes president, they could just revoke the memo and take a back seat and just cause everything to come down. So we don't think it's going to happen, but and the industry is full of a bunch of entrepreneurs, and no one's waiting around for that or planning for the worst, but it's looming there in the background. So we have a bunch of folks who come in and ask us about what might happen to me. We have clients in the industry who have been all in this industry for a long time, and they tended to be risk takers forever, so they're not really worried about this stuff. For them, this is like the easy stuff. But then there's other folks, landlords, property owners, just cash investors, partners, other folks who are not in the industry. They're hooking up with people in the industry, and they're entering into business transactions, and they're asking us, hey, I have a life, and I have have assets, I have other properties, I have other businesses. I see an opportunity, but I am not interested in, getting in any trouble. So, is this industry for me or not? We give them the speech that Tom said, it's against federal law, but we tell people, this is the enforcement policy. We think that you're okay. I mean, generally speaking, you're okay in the sense that the policy has existed for a while, an incredible infrastructure as every day goes by is being built up. It seems less and less likely that that's gonna come crumbling down, although it could. And it also seems to us very unlikely that it would somehow be revoked retroactively, meaning that even if the wrong person even if some particular person became president in 2016, or even if somebody decided to revoke the memo, it would seem almost implausible that they would revoke it overnight without warning and then, go after people who had been doing something in reliance on that current policy. So we tell people that if you are involved in a state compliant business, all indications are you're okay. And our law firm takes that position. I mean, we're aiding and abetting just as much as anybody. I mean, we're giving them advice and drafting contracts and doing business plans and financings and, I mean, you name it, every aspect of a business. And I sleep fine at night just because I think that we are helping people become compliant. And now having said that, the question is always a little more complicated. What if I know something bad is going on, right? So a landlord, common question is, well, what should I do? Should I build a bunch of provisions in a lease that say, of course you're compliant with state law, but how much should I monitor that? What's my obligation as a landlord to make sure they're compliant? And if they're not compliant, is that coming back on me or is that just them? Should I stick my head in the sand and not have any knowledge of anything? Or should I do ongoing due diligence to ensure? Those are interesting questions with no slam dunk answers. But generally speaking, I mean, that's the advice we give, and some people back away, and some people are taking a wait and see attitude, but other people are just going all in. So that's the framework and how we sort of deal with this stuff on a daily basis. And everything's evolving. 2015 is going to be an absolute crazy year. There's people down in Salem as we speak, and they will be there for the duration of the first half of the year. The OLCC is promulgating their rules. They're going on listening tours around the state. They are getting input. There's lobbyists. There's a lot of stakeholders sort of trying to lobby for this and that. There's 50 or 70 pieces of legislation that are now in various stages that are just being introduced on all kinds of cannabis things. There's folks who are trying to repeal entire sections of Measure 91. There's other folks that are trying to supplement it. That's going on the recreational side. Then you have the medical side where legislation is being proposed. So you've got the OLCC doing its rulemaking for recreational. You've got the legislature looking at recreational. You've got the legislature amending the Medical Marijuana Act, which is a very strange statute. It's a statute, despite 3460, which was sort of a transitionary statute. The medical marijuana statute was a patient's rights statute from back in 1998, right? It was never meant for a business. It was never meant to conduct commercial transactions. It was basically an affirmative defense against criminal prosecution. But what happened for 15 years is this economy developed around it and all these mechanisms for people to essentially make money. And then Sam's bill came in, which only tackled dispensaries. But right now there are processors, there are growers, and this is what we're operating on. We've been doing it for a year and a half, and we're going to do it for the remainder of this year, who are not licensed. I mean, you have major growers, warehouses, you have people making edibles on a vast scale that are not regulated by anybody. I mean, out-of-state investors, ask us what's the lay of the land in Oregon. I want to get licensed as a grower. Oh, you don't have to get licensed as a grower. Really? Yeah, you don't have to. All you have to do is register your grow site. There's there's 69,000 patients, like Tom said. There's another 60,000 grow sites that are registered. Now, a large percentage of these are people's basements. Nobody's looking at this. You can have a commercial operation in your house. That's all going to change. So that's the legislation that's happening on the medical side, where they're trying to turn it into a commercial statute after all this time, because Measure 91 is sitting there on the other side. So it would seem strange to have these two things that coexist, but one is so regulated and one's not regulated at all. So there's going to be a major issue on how they get combined, or if they get combined. And so that's going to be one of the big fights. Okay. So I have a whole slide on Measure 91, which, are these available to people? Okay, so I'm not going to go through the statute and what it says. I will say a couple things. One of our main themes, and this is sort of in stark contrast to Washington, and we saw Washington statute after it passed, and as a sort of a business entrepreneur, I was fairly appalled at it, because I thought the taxes were out of control, and it just wasn't meant to be. It wasn't drafted by business people, I would say. And so we came at this from a different angle and said, we need to have low barriers to entry. Our main goal here is to bring people into the system, to incentivize, business people, manufacturers, to come out of the gray market, out of the black market, get them in the system, and incentivize consumers to go to stores instead of buying, to continue what they're doing. In Washington right now, the prices have come down recently, but it's a very shaky system right now. So for a year, you had the black market literally get invigorated in Washington, because the prices of the stores were out of control. I mean, nobody would go to stores. There's a dispensary owner in Vancouver who I know, who had to call the police multiple times because there was dealers in his parking lot who were like undercutting his price in a major way. This is like an honest tax-paying guy who's leased real estate, who has built out a premises, who wants to pay taxes, and the prices he has to charge are outrageous. So we just came at it from a completely different angle, and we're trying to, again, keep the prices low. Our taxes are relatively low compared to Washington and Colorado, and I think that hopefully would lead to a vigorous sort of competitive marketplace, which I think could really take off. I went to the OLCC hearing the other day, and one of the commissioners said that, if we do this right, if Oregon does this right, this could be our Napa Valley in 5 or 10 years. Eventually, if the federal government changes the policy, and eventually looking down the road a decade or more, where you have interstate commerce, because right now, obviously, everything's intrastate. But if you have interstate commerce, I mean, Oregon growers grow very good weed. Oregon and Colorado will be the producers for the nation on a vast scale, which is just something that I think over the next decade or two, it's going to be interesting to see. So if anyone has any questions on the measure, you can email me. It's in the handout. It just goes through the whole thing. And we'll see how it turns out. But it's very interesting times.
Hi folks, I'm Marjorie Elken. I work with Zupancic Rathbone Law Group. I'm a lawyer. Like probably a lot of folks in this room, I started receiving a lot of calls from clients, not in the industry so much, but mostly folks who want to do business with the industry, landlords, what I would call ancillary service providers. And since I had had a client who was tracking this industry from way back when, I was really able to help them out and have been tracking it since the dispensary law passed and now Measure 91 passed. So I have a pretty basic little slideshow here. but I want to boil it down to some of the issues that are involved in commercial real estate. I'm going to briefly talk about the risks, the benefits, and then whether those benefits outweigh the risk is a completely individual decision. And if they do, then folks need to know how they can best legally protect themselves. And so that's what I hope to discuss the most with you guys. So, let's see. Oops. So in terms of the risks, we've already been through them, but if you speak with any lawyer, they're going to start with the fact that this is still illegal at the federal level. One more, yeah, thank you. We've already gone through that, so I'm not going to belabor the point. The important thing to note is that everything's still illegal. There is the Cole memo. I'll talk about it in a little bit. It's a policy statement. Like Dave said, so far, the prosecutors here in Oregon seem to be following it. They have no obligation to do so. Aside from those risks, there are also banking risks for individuals who want to do business with the industry, right? If you have a property and you want to lease it to somebody in the marijuana industry, you need to look at your own mortgage, if you have one, and your own notes with the bank to see if you have reps and warranties, like most do, that you're going to be in compliance with all laws, including federal laws, because a lot of banks, how they've attacked, or how prosecutors have attacked this, have gone after landlords and decided to do civil forfeiture actions. Banks get nervous. So a lot of banks, if they realize that you're leasing to a marijuana client, because let's say the checks that you're cashing come from XYZ dispensary or something like that, they're going to come and try and talk to you about how you're in violation of your own bank covenants. So that's just something to keep in mind when you're looking to get into this. Some other risks are sort of industry specific. Of course, any industry has its own risks. One of the main risks here in this industry is that right now, because banks are nervous about getting into it, it's a cash-only industry. There's a lot of cash in the industry. That creates real security risks for the folks who are in it. Hopefully those issues are going to be resolved by the time that we have retail operations here going in Oregon. But that is something to think about when you're talking to folks about leasing to them. So what are the benefits? I think there was a news article in the Oregonian on January 21st. Maybe some folks saw it. And I don't know if anybody remembers what happened on January 20th, but there was a State of the Union address. Here's President Obama. He got page 12. Here's pot, page 1. And in particular, Oregon's pot growers gobble up real estate to expand, meet demand for medical and soon recreational marijuana. And you read a whole article about how prices are just going up astronomically. Some prices for space is doubling. All of this is guesswork, by the way. We don't have regulations on the recreational side. We don't know what the OLCC is going to say about how far away from schools, if they even need to be far away from schools, that type of thing. But folks are just taking a bet based off of educated guesses of what's in Washington, and the medical marijuana dispensary laws, and Colorado, to see what property looks good and is trying to buy it up. There's only going to be a limited amount of property in the market that meets the criteria, and so rent on those types of properties is going to go up. You can charge more rent for those properties, not only because it's a limited supply of it, but also because there are inherent risks. Right? It's still illegal at the federal level. So that's probably the number one benefit of why folks want to jump into this market. Some of the other benefits, though, are that the tenants in this area, the folks who are really industry insiders, who want to actually comply with the law, want to be really transparent, and they're probably going to be good tenants and don't want to make a lot of noise and distract. They have a hard enough time getting into space. They certainly don't want to rock the boat. So you could look at some really good tenants if you get them in there. So onto the main point of the topic is, okay, let's say you decide benefits outweigh the risks. I understand it's illegal. I understand I could be prosecuted. How do I protect myself so that that risk is as minimal as possible? So, like I said, you want to talk to your bank first. If they're not going to waive the issue and you don't want to refinance or find a bank that's going to deal with that issue, you can always try and include protections in your lease requiring some sort of indemnification from the tenant. Of course, that's going to, indemnification clause is only as good as the tenant, and if the tenant has any money to pay it. But there are other workarounds there, but you really need to be aware of that risk and talk to your particular bank first. Then you're going to want to do some due diligence on the prospective tenant. Of course, I'm sure you do that with all tenants. There's some additional due diligence that I'll talk about. And then I can talk about some of the lease language that we advise our clients on. Each tenant and landlord situation is individual. You're going to want to, of course, individualize it for whatever you're working on, or talking to your clients about whatever their particular circumstances are. But there's some general themes that I'm happy to share with you that I talk to my clients about. In terms of due diligence, there's of course the typical due diligence that you do on any type of company that you're going to do business with. Like I said, this is a cash-only business. Some of these folks haven't been in business for a long time. That might be a little bit difficult in terms of credit checks and that type of thing. But the big thing is making sure that these folks are complying with state law. I would advise my clients at a minimum to go ahead and make sure that these folks are either applying for their licenses or have registered properly, if they're a dispensary, of registered property, something like that. Now, then there's always, like Dave said, there's this big gray area of how much more should you do. The Treasury Department has very extensive guidelines for how much due diligence banks should do. I'm not advising my clients that they necessarily need to do that much due diligence. I think there's some risk in doing that much due diligence, especially if you're not willing to follow through if you see a red flag, right? If you have a really good tenant and you do all this due diligence and all of a sudden you see this red flag on the tenant, some folks that I've found are like, well, we don't really want to do anything. We've got this great tenant who's paying all of this rent and everything else. So, whether you want to do all the due diligence, and it's in really small font here on the slide, of what the due diligence that banks are required to go through. But like we said, we can email these slides to anybody. I also have the address, the website where you can find the actual guidelines from the Treasury Department. Pretty dry reading, but worthwhile. So for each individual person looking to advise on this area or get into this area, I think one of your considerations needs to be how much due diligence do you really want to take on, and are you willing to follow through if you find something that you don't like in that due diligence. As a couple of examples in here, one of the things is ongoing monitoring of the business. You're supposed to look for suspicious activities, and there's a huge long list in these guidelines of what could be possible suspicious activities. I mean, you really need to dive into these banks would really need to dive into these businesses to see, are they making way too much money than they should for the size of their business, because that might indicate that it's an illegal operation. Like I said, I'm not advising my clients go through this much, but it's an individual choice. The other type of due diligence that is important is looking to make sure, to the extent that you can, that these folks are complying with these Cole Memorandum enforcement priorities. So like Dave talked about, there were a series of memos. The latest one was from Deputy U.S. Attorney Cole, and I think it's the next slide. And he came out and said, we have limited resources, and so I don't want you spending your resources going out and prosecuting folks who are complying with robust state laws that are trying to regulate this industry. What I want you to focus on are these 8 areas. And again, I've put them in the slide. It's preventing distribution of marijuana to minors, and making sure that, drugs aren't being diverted into illegal channels and things like that. Again, I've put the website, the web address for the Cole memo if you want to go and read it yourself. These are areas where, you know, because these are the areas the feds are going to focus on, you should make sure that to the extent that you know whether your tenant is violating any of these, you should try and see if they're violating any of these things. Again, I don't necessarily advocate for my clients going into, if I'm representing a landlord, going into their tenant's business and, you know, making sure they don't have any firearms or something like that. But if you're somehow aware of that, that should be a big red flag, because that's definitely going to be an issue for the feds. And my goal is to make folks who want to take these risks have as minimal risk as possible. Another thing to point out is that, thank you, is that Measure 91 mirrors, I think probably on purpose, the federal enforcement priority. So that's actually written into the law right now, that the people of the state of Oregon intend the provisions of this act to prevent all of these different things. So not only would your clients be violating state law, again, a big red flag. If they're doing any of these things, they would also be violating federal law. This is that would not be good. So after you've done some due diligence on your clients, then it's all about the contract, the lease, if it's a leasing situation, and how do you protect yourself. I'm looking at this more from a landlord perspective right now. This is I apologize for the very small font on the slide. So there are some definite provisions that you're going to want in there. Permitted uses should be pretty specific. There could be situations where you don't want it to be specific, but if you know, if you're a landlord and you know these folks are going to be in the marijuana industry, there's no point in sort of turning a blind eye, because now you already know. You might as well put in your lease very specific language. I would put, you know, things like a medical marijuana dispensary properly registered under the Oregon Medical Marijuana Act, and you know, continuing to be properly, obviously better language is continuing to be properly registered, that type of thing, so that you know that this is a medical dispensary. If all of a sudden these folks want to turn into a recreational operation, that's a different thing. They can't do that under this particular lease. So that's pretty important. A big thing for landlords is going to be an escape clause. Sort of the overall theme here has been, this is a big question mark, right? We don't even know what the regulations are in Oregon right now, and we certainly don't know what the federal government's going to do. So if Holder's replacement comes in, you don't want to be stuck in a lease saying that you're going to lease to a marijuana operation, and that marijuana operation has a much higher risk tolerance, and all of a sudden the replacement comes in and says, by the way, I'm going after all you folks, right? So you want to have something in the lease that says that if there's a change in policy, if there's a change in state law, if there's a change in the regulations, that you're able to get out of the lease, right? There's going to be some sort of escape clause. It's also probably a good idea for a landlord that if the landlord receives any sort of governmental action or any sort of letter from their bank or something like that that's threatening their property, that they could get out of the lease. That's a good option. Then you talk about representations and warranties. Of course, compliance with all laws. I would be a little bit more specific. There have been cases, primarily out of California, where that type of language is just a little bit too broad. And folks say they don't know if it's state law, and folks are in compliance with the California state law or whether it's federal law. So compliance with the particular state law. If it's a medical marijuana dispensary, the Medical Marijuana Act. If it's recreational, then Measure 91. Compliance with federal policies, right? You can't say compliance with federal law because they're already out of compliance with federal drug law. So maybe compliance with non-drug related federal law, or compliance with federal enforcement priorities. I have in certain documents actually specifically said the Cole Memorandum. You also would be wise to talk about saying that you as the landlord could require them to provide proof of their compliance. That's a pretty easy thing to include. like I said, most folks in this industry who want to be transparent aren't going to have a problem with that, and then it crosses off one more hurdle. Some things that folks might not think about, and it's hard to actually draft around this right now in leases because we don't know what the regulations are, but there are going to be some operational impacts. For instance, producers might be subject to regulations regarding waste, wastewater issues. Growers certainly will have issues like that. Right now it's hard to draft around those things, but you should think about them when entering into leases. Another thing is that if somebody wants to be a grower near the landlord, knowing a little bit about the industry would be wise. I mean, it takes an immense amount of electricity if they're going to be an indoor grower to do the growing operation. This article that I referenced talked about a 5,200 square foot facility that had a $1,400 a month electricity bill, and they were trying to be as efficient as possible. Water usage can be really huge as well. So these are things that you should certainly think about. There's also nuisances, odors, consumption on the premises. Right now, under Measure 91, you can't consume in public, so you don't want folks outside of your retail operation smoking their joints. Odors are going to be big. Marijuana has a particular odor. It's pretty pungent. Other tenants, if they have neighbors next door, may not like the odor. So those are all things to think about. Some other things there are industry-specific insurance. So you might consider including insurance, when you're talking about insurance requirements in the lease, including industry-specific insurance requirements, or at least talking to I'm sure somebody in the industry would know about that, but it's something that, if somebody comes back saying I can't get insurance, it's probably not accurate at this point. And then just knowing about that there could be zoning issues, and knowing about that right now, if folks are actually working with people who want their space for retail operations, it's a big question mark. You're going to have to put some, what lawyers call wiggle room in the lease to make up for the fact that we don't have regulations. But there likely will be an application process that these folks have to go through with different stages. That's a guess. I don't know what the OLCC is going to do, but that's what other entities have done in this situation. And so talking about if they don't, thinking about escape clauses related to that application process that you could get out during certain phases. And then, of course, most importantly is just keeping track of the regulations, because they're going to be changing. They're going to be changing for quite some time. Even when we get the first round of regulations, they're going to go through some pretty substantial changes, and it'll be pretty important to keep on track of those. That's all I have. Should we take some questions?